Good morning. I'm Trevor Morrison. I'm the Dean at NYU School of Law, and it's my pleasure to welcome you all from literally around the world today as we celebrate the career and now the retirement of our dear friend and colleague, Professor Jerry Cohen. Jerry has had a career that could not have been imagined before it happened. It spanned 60 years, with the last 30 at NYU. He is truly a giant in the field of Chinese law and East Asian legal studies. His voice is among the most important in the world on issues affecting the region, on issues of law and politics and policy. He's been a groundbreaking scholar and public intellectual who really in the West envisioned and created the field of Chinese legal studies and more broadly East Asian legal studies. At NYU, Jerry co-founded the U.S. Asia Law Institute and served for many, many years, of course, as its faculty director until turning the reins over this past year. Jerry will continue his scholarship on Asian law as the USALI's faculty director emeritus, and for that, we are very grateful. Now, to celebrate his career and to mark his achievements and his retirement, Jerry's longtime friends, Andrew Duncan and Bess Weatherman, really led the charge to establish the Jerome A. Cohen Professorship of Law, seeding the effort to establish a chair in Jerry's name. They recruited a number of Jerry's former students, scholars, and friends. We're especially grateful to Jack Huang, chairman and founder of Taiwan Renaissance Platform, and Daniel Tsai, chairman of Fubon Group, for their support of that chair as well. And with all of their support and the support of others, we were able fully to endow the Cohen Chair, and we are thrilled to have that as part of our faculty and are in the midst of recruiting a potential occupant for that chair, and it will be a wonderful, really legacy that here at NYU, marking Jerry and his fantastic achievements. Speaking of support, I also want very much to thank the government of Japan for their incredible support of the U.S. Asia Law Institute. The $5 million grant that they provided to us a few years ago now is really the core of our effort to establish a permanent endowment at USALI. Our goal ultimately is to be able to name USALI as well after Jerry. As we work towards the full endowment that will be required for that, the grant from the Japanese government is already tremendously important to the work of USALI, to the research being done there, to the programming being put on. We are thrilled by all of this support and just really grateful that it can be a way of helping to mark Jerry's tremendous accomplishments in these fields, and very grateful to all of you for joining us this morning, as I say, to celebrate his truly outstanding career and his long friendship with so many of you. Without further ado, let me turn things over to Jose Alvarez, our Herbert and Rose Rubin Professor of International Law and the new Faculty Director of the U.S. Asia Law Institute. Jose?
Thank you all. Thank you, Trevor, for that. And good morning, good evening, and everything in between, since I know so many of you are tuning in outside of New York time. So one of our former deans here at the law school, John Sexton, was known as the consummate deal maker. If anyone was entitled to a writing The Art of the Deal, it was really him. When he enticed Jerry Cohen to leave Harvard Law School and join NYU back in 1990, I think he struck the best deal of all. NYU got, to be sure, a pioneering scholar, someone who started in this field with a path-breaking book on Chinese criminal legal procedure, and would go on to write a dozen more books on everything from disputes involving the South China Sea to, most recently, Taiwan's unique posture and embrace of international human rights. As a scholar, Jerry has written not just about arcane matters of interest to academics. He has wrestled with the most important, difficult issues of the day, such as threats to international peace in the region, involving, for instance, Hong Kong, Taiwan, or certain islands in the South China Sea, to threats to human rights defenders. We have also been privileged, thanks to his recruitment, to get a thoughtful practitioner with vast experience in real-world law firm practice. As someone who repeatedly advised U.S. clients seeking to do business in China, Jerry followed a noble NYU tradition of seeing public and private international law, as well as foreign law, as a seamless whole and not a matter of distinct mindsets or casebooks. Our students also got a devoted teacher whose close attention to their research and, of course, their career needs remains a legend. Sexton knew he was getting someone who not only had established a new academic field, Asian legal studies, but a rare visionary who knew how to institutionalize it, as he did first at Harvard and later here with the establishment of the U.S. Asia Law Institute, or USALI. And of course, Sexton brought to NYU the most effective public advocate in the field, a consistent voice of conscience for mutual understanding, justice, human rights, and the rule of law. Jerry's career shows how a single individual can make a difference, in no small part by building lasting institutions that carry on his work. Today we celebrate Jerry along with his creation, USALI. Jerry's goals for USALI were deceptively simple. He wanted to establish a preeminent research center for the study of law in Asia, a place for constructive engagement with Asian partners to further legal reform there and here, consistent with the rule of law, for educating students and the greater public about legal developments in that region, particularly in mainland China and Taiwan. Since 2006, USALI has carved out a unique space for U.S. Asia legal exchanges. Thanks in large parts to Jerry's incomparable diplomatic skills, no other institute has managed to support legal reforms in China and elsewhere, especially criminal justice reforms involving judges and prosecutors from the region, while also serving as a venue for honest, well-informed, critical commentary, most notably, but not only, on human rights. Today, even in the face of COVID's many challenges, USALI continues this multi-track approach. Even as funding for legal reform projects based in China has become more scarce, we continue to look for ways to use the law to pursue justice while also influencing those who write and teach it. We continue to think, as Jerry always has, that doing justice and teaching it amounts to the same thing. Now and in the future, we still want to be a neutral convener for informed commentary from all sides that is nonetheless able to empower voices that would otherwise be silenced by governments, whether here or abroad. At a time when the US and China threaten to decouple and the US ties to multilateralism are strained, USALI is more important than ever. We seek to be both creative problem solvers and academic innovators, as through, for example, an ongoing ambitious project led by USALI Senior Fellow Peter Dutton, who you'll see shortly on our first panel, that examines the methods used to settle maritime disputes. At a time when some of these disputes are at risk of escalating into an actual shooting war, we hope to establish a toolkit that both adjudicators, policymakers, and professors can use. These hybrid goals also explain whom we invite, the topics we address in our weekly speaker series. They also explain why we are launching in a couple of weeks a new online essay series called USALI Perspectives, which will explain and analyze timely legal issues facing the region and will provide a new platform for new as well as familiar voices. In these ways, we seek to deepen our interest in the Asian region as a whole, while also embracing one of the law school's renowned assets, its unrivaled expertise in international law. We also seek to strengthen USALI's ties to academia by continuing to welcome young scholars from the region, but by also deepening the Institute's connections to another one of NYU's strongest assets, namely the presence of what is perhaps the nation's strongest cohort of US and foreign-born law students. To that end, my colleague Frank Upham and I began teaching just a few weeks ago USALI's first colloquium offered for academic credit. We hope that our course called Globalization, International Law, and East Asia will become a perennial course offering where JD and LLM students can interact with prominent scholars to produce scholarship that is worthy of Jerry Cohen's legacy. We are pleased that our events, particularly our weekly speaker series, are thanks to the magic of Zoom, reaching greater numbers of people than ever before. Of course, we look forward to the day when we are able to resume in-person events and to meet across a seminar or conference table with many of you, Jerry's friends and ours. We are very grateful to our financial contributors that Trevor has mentioned for making all of this possible, and we hope to be able to count on the support of all of you participating in the event so that USALI can continue to preserve and extend Jerry's legacy through the next generation. At this point, let me introduce Catherine Wilhelm. Catherine, who became USALI's executive director in August of 2019, is a distinguished expert on China's legal system. Having lived in the region for nearly 3 decades, she served as a corporate lawyer and as a journalist, and immediately before joining us, Catherine was the legal program officer at the Ford Foundation's China office. She has considerable experience on projects involving, among other things, criminal justice reforms, women's rights, and media law. So at this point, Catherine, over to you to continue our introductory program. Thank you all.
Thank you, Jose, so much. And thanks also to Dean Morrison for always offering such strong support for the work of our institute. As Jose notes, I have been with the U.S. Asia Law Institute for a little more than a year now, but I knew the institute for some years before that because while I was at the Ford Foundation, I did support its work and its projects. And the reason that I supported it, which is the same reason that I decided to join the institute, is because under Jerry's leadership, we have really played a unique role. Yes, we promote mutual understanding, but more than that, we have built durable relationships between the legal communities in Asia and in the United States. And your participation today is testimony to those relationships. What I'd like to do now is bring the camera up for our guest of honor, Jerry Cohen. And let me see if we can, Jerry, if you can click on the unmute and on your camera. There you are. And also with you today, I think, is another special guest, Joan Lebold Cohen. Is she?
You could be seen there, good.
Maybe can come a little closer to the camera and say hello. I just wanted to mention Joan Cohen as well, because many of you know her and she's part of our celebration today. She's been part of all of Jerry's Asian adventures while also carrying on her own career as a photographer and a published author. And so we wish we could be sharing hugs in person, but it's good to know that you're there and welcome.
Good. Thank you.
So now I'm going to briefly explain the rest of today's program. Our objective, of course, is to celebrate Jerry and his contributions, which still continue even after his official retirement. But we knew that we would not be able to spend today 2 hours making speeches in Jerry's honor because he simply would not stand for it. He told us that it would be boring. So we are going to honor him by holding 3 mini panels to discuss topics that have been recurring themes in his work since the 1960s: public international law, arbitrary detention, and the development of democracy and the rule of law in East Asia. And each of these panels will take the form of a conversation among Jerry and the discussants, who are all leading authorities in the field, as well as friends, colleagues, and in some cases, former students of Jerry. And these discussions will be an attempt to answer one of Jerry's favorite questions, which I'm sure is familiar to many of you: what is to be done? What should we as scholars and lawyers and legal professionals be doing? The final portion of the program is going to be open mic. This is an opportunity for more people to say a few words to Jerry or about Jerry, or for that matter, to raise any comments or questions for any of the discussants. So if you would like to speak then, what you can do is enter comments in the chat portion of the Zoom app during the course of the program, and we will be sampling from that as we get into the open mic period and try to call on as many people as we can. So very quickly, as time is tight, our first panel will begin now. And the staff will start turning on the cameras for the discussants in that panel, which is about public international law. Jerry will be joined first by Ma Ying-jeou, former president of Taiwan, former minister of justice and mayor of the city of Taipei. Hisashi Owada, former president of the International Court of Justice, former Japanese representative to the United Nations and the OECD, and holder of many other diplomatic positions, scholar of international law. Also Peter Dutton, professor of strategic studies at the U.S. Naval War College, adjunct professor at NYU School of Law, and a senior affiliated research fellow at our institute. And Jose Alvarez, whom you've just met, who is professor of international law at NYU Law School and our new faculty director. As I said, these themes that we've selected to talk about today have been abiding themes in Jerry's work. He started teaching Chinese views toward international law in a course at Harvard Law School in 1968. And in 1974, he and Hongda Chiu co-authored what I believe is the first book written about the People's Republic of China and international law. So Jerry, I'm going to keep time from off stage, and I will jump back in when 3 minutes are left.
Great. Well, I don't see, there's Judge Owada. Welcome, Hisashi. So glad you could join us. And now what's happened to, there's President Ma, and I'm thrilled that you could make it. And you're an expert on international law. You've done a lot to lead Taiwan's progress in international law in practice as well as scholarship. And we're thrilled you could be with us. Please give us your thoughts.
Ladies and gentlemen, good morning. Greetings from the Republic of China on Taiwan. I have 3 points to make. First of all, Jerry was my SJD dissertation advisor in 1978 at Harvard Law School. After I became president of the ROC in 2008, he asked me what I learned from the US that I thought was the most valuable for Taiwan. I instantly replied, protection of human rights. Taiwan's transition from a country under martial law to a full democracy took more than 30 years. The American influence played a vital role. In the last 60 years, at least 1 million Taiwan students have studied in the US, and many have come back to Taiwan to support the transition. I was just one example. In 1971, I was a third-year law student at National Taiwan University. I visited the US for 70 days under a State Department program for Asian Pacific student leaders. It was an eye-opening trip for me. When I became president of the ROC 37 years later, in March 2008, I received a congratulatory message from President George Bush Jr. saying that Taiwan is a beacon of democracy to Asia and the world. People in Taiwan felt so proud and were so grateful to the US. The second point is the US attitude toward international law of the sea. For 40 years, the US has carried out the freedom of navigation operations by sending warships to enter the territorial seas of other countries without prior authorization or notification. The US argues that its warships have the right of innocent passage in the territorial seas of other countries under the law of the Sea Convention, to which the US is not yet a party. In October 2016, when the US sent a destroyer into the territorial sea of China's South China Sea Islands, it criticized China, Vietnam, and Taiwan for making excessive claims against foreign warships' right of innocent passage. In fact, both mainland China and Vietnam require prior authorization, while Taiwan only requires prior notification under its domestic law. It is clearly unreasonable to require Taiwan, a country whose national security is at stake in the Taiwan Strait, to allow any foreign warship to enter its territorial sea without prior notification. In fact, state practice shows that 42 countries in the world have such prior notification requirements. It is fully legitimate for a coastal state to safeguard its national security and should hardly be called excessive. But the US simply ignores that. The third point is also related to the law of the sea. US Secretary of State Mike Pompeo called upon the world on July 13 this year to support the arbitral award rendered in July 2016 by a 5-member arbitral tribunal that heard the case brought by the Philippines against China concerning the South China Sea. The award says there's no island in the whole South China Sea. All the land features are rocks under the law of the Sea Convention. While the award is right as regards many reefs there, but Taiping Island, known as Ituapa in the West, is an obvious exception. It is the largest natural island there with an area of 120 acres. It has ample supply of clean water and can grow 20 types of vegetables and fruits. There are 200 people living there who raise chicken, lamb, and fish. It has a harbor and an airfield. There's a hospital with 10 beds, 3 doctors and 2 nurses who have treated dozens of fishermen from the area. So, living conditions on the island are far better than the description of the American attorney retained by the Philippines, who said that Taiping Island has to import everything from outside except air and sunshine. Obviously, the tribunal was seriously misled and rendered an award on the basis of misinformation. If the U.S. supports this arbitral award, then its 3 naval bases on the tiny Baker Island, Howard Island, and Kinmen Reef in the North Pacific should not be allowed to claim their exclusive economic zone as they do now. Thank you for your attention. Thank you.
This is the way to get this meeting going. This is the kind of substantive discussion I wanted. Thank you very much. I agree with you on some points, and as you know, I don't agree with you at all. But you've done a fabulous job in launching this, Yingzhou. Thanks a lot.
Thank you. I appreciate that.
I look forward to what Judge Owada, who's one of the great experts on international law, can tell us. Recently retired from the International Court of Justice. He came to Harvard at NYU at Jose's invitation, and he's been at the UN. He's taught at NYU for 2 years, as well as at Harvard earlier. We're thrilled that you could be with us. Thank you, Hisashi.
Let me first of all congratulate Jerry. My tremendous congratulations on your 90th birthday, which is really unbelievable. You look like when I met you for the first time in 1970s. And you are still active intellectually and physically, and you are doing very good things for your own country. Now, given the time factor, let me start with 3 brief points. I'm supposed to talk about public international law, the present state of public international law. Given the time factor, I'd be very brief. The first point I should like to make is that if you think about the 30 years ago, late 1980s, the Cold War was declared to be over. The then president, George H.W. Bush, made a declaration that a new international order is coming. Everybody was expecting that. During the Cold War days, of course, there were 2 conflicting, not only major powers, superpowers, but also conflicting spheres of interest and spheres of doctrines. Soviet international law and the liberal free world international law. Someone lamented the fact that we had 2 separate international laws in one world. Now, that was over. But when that was over, everyone expecting that from now on, there's going to be one international order under the leadership of the countries which have achieved the victory over the other side. That has not been the case. In fact, after in 30 years since that time, following 30 years, we have seen lots of violations of international, obvious patent violations of international law, such as, for example, by Russia, the invasion into Ukraine, the annexation of Crimea, and others. And then, of course, you have China claiming the territory over the islands in the South Pacific, and also East China Sea. And that, of course, was not only a dubious assertion on the part of China, but China, in fact, rejected the arbitration by International Court of Arbitration, Permanent Court of Arbitration, which I think is even a greater challenge to the established rules of international law. And then, of course, the United States is no exception, in the sense that the current president has unilaterally decided to withdraw from the Paris Accord, the agreement on the Iranian nuclear deal, and many other things which could be sufficiently questionable from the viewpoint of public international law. Now, that's not only the case. I mean, that has a contagious effect to other countries. And I think that's where we are now. The second point I would like to make is, how do you make of the present state of public international law in the world? Now, when the major powers try to ignore the established rules of international law, the international legal order would become very fragile, because other countries will try to follow. This has a contagious effect in the sense that other countries would like to emulate this pattern of behavior. There's one exception, which is East Asia, for instance, fortunately. Of course, there are, with certain exceptions, there are many regional conflicts, but countries in East Asia tend to be observing rules of international law to the extent that they have come to agree with the doctrines and the principles involved. We have had cases between Singapore and Indonesia, Singapore and Malaysia, both in relation with the territorial title between the two states. We have a dispute between Cambodia and Thailand. We have a dispute between Australia and Japan in relation with the Antarctic whaling. Now, all these things have been referred to the International Court of Justice, where I used to work. And I had dealt with those questions as a judge of the International Court of Justice. And it really demonstrates how important the rule of international adjudication is in order to settle disputes, in order to bring about an international order which everybody respects and everybody tries to abide by. And the unfortunate thing is that when major powers tend to ignore the rules of international law, then, of course, the fragile structure of public international law becomes very, very weak and disappear. This reminds me of the period between the two centuries, from the 19th century to the 20th century, when the then powers, then great powers of Europe, tended to bring about more orderly, more stable international society. And this was the time when, of course, the first industrial revolution has come to produce some results in terms of industrial revolution, communication, development in communication, and so forth. And then, of course, the Wilhelm of the Netherlands and Nicholas II of Russia agreed to hold a peace conference in The Hague, and that produced not only the humanitarian rules in the armed conflict in the war, but also the system of international adjudication based on the example established by the arbitration between the United Kingdom and the United States at the time of the Civil War, Alabama arbitration. And that set the good example which led to the present state of international legal stability up to the present day. Now, the other thing, of course, is that in those days, people were much more idealistic about the future, idealistic and utopian, and if you like, and also optimistic about the future of the world. And they tended to agree that the future of the world will depend upon the stable, just international legal order. And the powers in Europe tended to follow that public opinion in those days. And the final point I would like to make, the third point in response to the question raised by Professor Jerry Cohen, is what to do now. I think what is really important is to amalgamate, to codify, to bring up together the voices of the world towards the recreation and consolidation of the international public order based on the consensus of the entire world. Now, people say that some countries which were the result of the colonial period tended to think that international law is a bunch of rules which were created during the imperial, during the days of imperialism and colonialism, and therefore we cannot abide by it. I don't think that is true, and in fact, as a result of the codification efforts in the post-Second World War, in which many of the African countries and Asian countries have participated, they have already been participating in the creation, application, and the execution of international law. And that is very important in order to create the stable, just international legal order with a sense of participation. And I think that the kind of exercise that Jerry Cohen and his institute at the NYU has been trying to do to work together with the Asian countries is an extremely important element for that. I personally had also been contributing to the creation of Asian international law as a forum of dialogue and coordination between different countries in the non-governmental groups, scholars, practitioners, and governmental officials and so forth. And I think that has been going very well. It was created in 2007. And I hope that we should try to promote that kind of efforts all over the world. Thank you.
Great.
Jerry.
Thank you. That was a terrific appeal for greater cooperation. We've heard now 2 challenges to the United States. Now we're going to hear from my colleague, Peter Dutton, with whom I think for 8 years I have co-taught a very good seminar from which I've learned a lot on China and international law. Peter?
Good morning, Jerry, and greetings to you and Joan, and greetings, President Ma. Greetings, Judge Owada-san. Greetings, Jose, and to all the participants. I've been asked to address a lot of the C issues, as Jerry indicated, and in particular, the most urgent issues right now. And this is an issue that Jerry identified years ago, and which the U.S. Asia Law Institute continues to focus on going forward. And because of his efforts, we're continuing to focus on it. And that is the return to the primacy of law as the mechanism of international stability in the maritime domain in East Asia. That's a key concept that we are focusing our efforts on. This is a particular problem in East Asia, of course. I'll talk about that in a moment, but it's not unique to East Asia, as we've seen flare-ups recently in the Western Mediterranean and the Black Seas and elsewhere, including the Arctic in recent years. But in the East Asia maritime domain, we see the South China Sea as the locus of what amounts to a power grab over maritime space. There is a unique, if I'm being polite about it, approach taken by certain states to their international law and to their claims in the South China Sea. The South China Sea arbitration showed this, that some of these approaches to legal claims have no basis in international law. In the East China Sea, power dynamics have attempted to replace legal solutions to issues and disputes between the parties. Power has replaced law as the mechanism of settling disputes across maritime East Asia. And of course, this brings with it the danger of conflict. In the international sphere, power and law have always worked together, but power must be directed at achieving legitimate aims, as defined by international law, not as defined by narrow national interest. In response to President Ma's point about the United States, I think it's ironic, actually, that it is international law that restrains and keeps stability between the United States and the People's Republic of China in our interactions in the maritime domain of East Asia, even as our militaries rub against each other in uncomfortable ways. I think this demonstrates that law is useful in limiting the powerful. The US and the People's Republic of China have a certain predictability, even in our interactions in East Asia, even in our differences, because we understand that they're based in a law-based approach to our interactions there. But in East Asia, it seems power, not law, dominates the maritime disputes, especially those involving a strong state and a weaker state. You can see this throughout the various approaches to maritime claims, in the way states claim baselines, in the way states claim resource zones, in the way states make boundary of those resource zones, and in the law enforcement rights that they claim within them, and even in the role of historic rights. This is why the U.S. Asia Law Institute, under Jerry's leadership, undertook a project on maritime dispute resolution, asking what can be learned from the record of settled cases. What lessons might be applied to the maritime issues and disputes in East Asia? How can we help advise governments to be useful in finding practical solutions to very real and potentially dangerous problems? The first report of our research, called Testing the Boundaries, can be found on the U.S. Asia U.S. Asia Law Institute's website under the research tab, and the second round of research will soon be added to it. This is an ongoing project where we're going to continue to learn more and more about the ways in which international law can in fact help parties even in the midst of a seemingly intractable set of disputes. We will be developing ideas to help the governments bring international law back to a position of primacy as the mechanism of maritime stability in East Asia, not just between the US and the People's Republic of China, but between all countries, as a way to protect the rights of weaker states. And again, in closing, I'll just say, Jerry, it's been a privilege to be teaching with you and to thinking through these issues together. I think we've really generated a lot of good thought and a lot of good research, and I look forward to many more years of working together with you on these problems.
Well, Peter, thank you. That was terrific. And now we hear from our fourth expert on public international law, Jose Alvarez. And I must say, one of the achievements of Dean Morrison's administration was persuading Professor Alvarez to join Professor Frank Upham in continuing the work of our U.S. Asia Law Institute. You'll hear from Frank a little later. He co-founded the Institute with me, and we're delighted that Jose has taken root and brought his great knowledge of international law to these issues. Jose, please.
Thanks, Jerry. But one of my roles here is to keep us on track on time. And unfortunately, this panel was already set to end. So I'm going to be much, much briefer than my colleagues who have pretty much laid out issues. Right now, as all of you I think know, in about a few weeks' time, we're going to face a major election in the United States. And in that election, international law is on the ballot as far as I'm concerned. And if you think about all the challenges that either the re-elected Trump administration or a Biden will face, from climate change to threats to international peace and security, from nuclear proliferation to respect for international rule of law and international dispute settlement, to what some people think is the demise of human rights and its implementation, to trade and competitive concerns. All of these run right through East Asia, especially the rather extreme rhetoric on global domination that you might hear even from Biden foreign policy supporters. That is the perception that the rise of China means the demise of international law. Tomorrow, for example, in our weekly speaker series, you will hear Tom Ginsburg say that it's the rise of authoritarian international law. And he says that that's because China is now at the forefront of taking over in international institutions, in promoting soft law instead of hard law, in making looser cooperation, in negotiated settlements outside courts of law, and in specific areas as well. In a few more weeks, you'll hear from other two scholars, Greg Sheffer and Mr. Gao, talking about a new Beijing consensus with respect to international economic law. My personal view is that even though there are extreme challenges and concerns posed by the rise of China, we lose sight of the fact that great powers have always used international law to their big benefit, leaving everybody else in the wake of the two gorillas fighting. And sadly, I think what we're seeing is China emulating some of the very worst tendencies of using what I would call hegemonic international law for the same purposes. I'm not equating US and China necessarily, but I am saying that those who fear China so much for its tendency to dominate the world through international law lose sight of the fact that a full decoupling will prevent us from solving climate change, threats to use of force, nuclear proliferation, all of which will require some level of cooperation between at least the US and China. So I'll stop right there in the interest of time.
I think we have demonstrated the need for a 2-hour Zoom session to pursue these issues, starting with the agenda President Ma has given us. Toward the end of the program, if there's time in the open mic session, I'd like to answer my own views of some of these questions, but certainly we need to have a Zoom program with Judge Owada, President Ma, coming to us at least via Zoom so we can have a serious discussion. And finally, I just want to say, President Ma got his LLM at NYU Law School before going to Harvard. So that was a further reason I wanted to be sure we included him. Well, now on to an even sadder question of arbitrary detention, which is even today my abiding interest.
Okay, thank you, Jerry and discussants, for all of these thought-provoking suggestions and insights. Unfortunately, we do have to keep rushing along because we only have 2 hours total for our program. So we're going to ask the current panelists to step down, and we're going to bring up the next panel, which is about arbitrary detention in China, including Hong Kong. And Jerry will be joined this time by Ira Belkin, Senior Research Scholar at the U.S. Asia Law Institute and Adjunct Professor at NYU Law School. Ira will be familiar to many of you because he was our Institute's first executive director, my predecessor. And also with him, Yujie Chun, who is an assistant professor at Taiwan's Academia Sinica, and she is also an affiliated scholar with our institute, and Daniel Yuping, who is an independent scholar, senior advisor of UDA Education Consulting Group, and a former senior fellow of the NYU Law School China program.
Well, let's get started, Ira. I was thrilled when we had breakfast one day a long time ago in Beijing, and I was able to persuade you to leave the Ford Foundation in Beijing and join us. And you're as expert on criminal justice in China as anyone. And I'm eager to hear your thoughts now that you've recently been liberated from the obligations of being executive director of USALI.
Well, Jerry, it's wonderful to see you. I miss seeing you on a regular basis, but it's great to see you at this event. And I just want to say hello to everybody who's joined us, both as panelists and also as audience members. It's a great occasion. I want to use my 5 minutes to try to answer a question that Jerry asked in a recent article he wrote. The title was Helping China Build Its Post-1978 Legal System a Mistake? And you can find Jerry's article on the USALI website. So I want to use my 5 minutes to make an argument that Jerry, no, that was not a mistake. And it was essential then, and it's even more essential now. I was struck by President Ma's testimony about when he became the leader of Taiwan, that he remembered his studies in the United States, and he summed it up by saying one of his missions was to protect human rights. And he talked about how he was one of 1 million Taiwanese students who studied in the US. I think his example of Taiwan is instructive for us. The power of engagement is real. It's fashionable in the United States today, especially in Washington, to devalue the efforts and the results of engagement over the years with China. Arbitrary detention is one of the major human rights problems that has plagued China since the founding of the People's Republic of China and even throughout the legal reform period. But certainly the situation today, with all of its many problems, which our panel is going to go through, is still a vast improvement over the pre-1979 period in China and even during the early years of reform. I want to use a couple of examples of the work of the U.S. Asia Law Institute. During the time I worked with Jerry, and even before I came to NYU, we focused on several issues in the Chinese legal system. Re-education through labor, a form of arbitrary detention, administrative detention without judicial process or due process. We focused on problems in the criminal justice system, long periods of pretrial detention and investigative detention. And we worked with groups of Chinese legal scholars who were working on reforming the system from within, and supported them and worked with them over the years. And that cooperation in many cases has borne fruit. I remember going with Jerry in Beijing to meet with a small group of scholars who were working on the abolition of re-education through labor. Re-education through labor was several years later abolished. Unfortunately, not all forms of administrative detention have been abolished, and some new ones have appeared. But that was a remarkable achievement, and it was the work of many decades of people within China and outside of China. Jerry and Maggie Lewis wrote an important book about how Taiwan abolished its version of re-education through labor. So that's one example of how engagement and cooperation can lead to tangible results, but there are many others. The U.S. Asia Law Institute worked for many years with Chinese scholars on how to deal with the problem of pretrial detention. Almost all individuals suspected of a crime in China were detained, and although there was a possibility of release based on bail, it was never really implemented. And in 2012, the reformers were able to get into the criminal procedure law a requirement that detention must be found to be necessary. And after that, we held a series of workshops and meetings with Chinese reformers that resulted in additional reforms and pilot projects all over the country to experiment with ways to use risk assessments and other tools to release more and more people pre-trial. All of those efforts were captured in a book, which we published and which you can find on the U.S. Asia Law Institute website. We worked tirelessly on the problem of torture during pretrial detention and police interrogation. And over the course of many years, not just as the result of our work, but many other institutions and folks within China, China developed a requirement that all police interrogations had to be recorded, and an exclusionary rule for coerced confessions. The system's not perfect, far from perfect, but it's a big improvement. And China in recent years has reported many, many cases where the defendants have not confessed, which was virtually unheard of before those reforms. So my point is that engagement can work, it can produce results. It's slow, it's not sexy, it doesn't make headlines, but it's important. And reform takes place one step at a time and not all at once. Sometimes you feel like you're helping in a small way to bend the arc of history, and sometimes you feel like you're playing whack-a-mole. But what's the alternative? The notion for all of those people who are angry at China, and China unfortunately gives many people reasons to be angry, but all of those people who say we should decouple with China, we should close our consulates, we should end our Fulbright program in China. What is the end game? China is more important than it's ever been. And the idea that at this moment we should pull back from engagement with China simply makes no sense. So to Jerry's question, no, helping China was not a mistake. Engaging with China was not a mistake. And it would be a terrible mistake if we continue down this road of so-called decoupling and shooting ourselves in the foot. We have, over the years at the U.S. Asia Law Institute, built up a tremendous set of great relationships with Chinese scholars. And as China becomes richer, stronger, more powerful, the need to engage with those scholars is only greater. And it would be a shame and a waste not to take advantage of the resources that we've developed and the relationships we've developed. In large part, thanks to you, Jerry. So I rest my case, and I hope that the U.S. Asia Law Institute continue along the road of engagement that you started us on many years ago.
Thank you for very articulate support, and I don't disagree with the word you've said. We're lucky today to have, following Ira, Miss Yujie Chen. She is a distinguished product of NYU's graduate education with the LLM and a doctorate in law. She's done great work for us, and she was recently at Hong Kong University on a distinguished fellowship, and now has a great job at Academia Sinica Law Institute in Taiwan. She works with us on scholarship relating to the mainland, Hong Kong, and Taiwan, and is engaged in very important effort to expand our understanding of what's taking place in Greater China. So, Yujie, we're happy that you could join us.
Thank you for the kind introduction, Jerry, and greetings to Joan and all participants. My remarks today will focus on Hong Kong and the newly enacted national security law. But due to time limits, I won't be giving legal analysis of the NSL, which I think people have been getting in the past 3 months. And I want to put a plug in here for Jerry's blog. It has many postings of Jerry's insightful analysis of the national security law. So if you haven't subscribed to the blog or follow him on Twitter, go do it now. I really appreciate today's forward-looking approach that Catherine mentioned in the beginning. So what is to be done? The national security law is designed to punish certain speeches and activities unwelcome by the authorities, and by doing so to create self-censorship and silencing effects in the news media, in academia, and among the public. So just on July 1st, the first day the law was implemented, 370 people were detained, and among them 10 people were arrested under the NSO, including later including the well-known media Jimmy Lai and activist Agnes Chow. So far we know that by September 25th, 28 people have been arrested under the NSO, although most of them were released pending investigation. And so far, we've also got the first case charged under the NSO. The defendant, Mr. Tong In-kit, has been denied bail. There will be more NSO cases that will be charged and enter the courts in the future. So what can be done at this point to mitigate the damage by the NSO to Hong Kong and beyond Hong Kong? Some scholars have argued that we should take the rights protections clauses in the NSO seriously, as well as human rights protections embedded in Hong Kong's legal system and judicial practice. I cannot agree more. For example, Articles 4 and 5 of the NSL, which offer protections of human rights, the rule of law, and the presumption of innocence, etc., should be taken full advantage of instead of being treated as window dressing clauses, as some suspect they are. So while there are provisions in the same law that contradict, apparently, Articles 4 and 5, what we can do in the legal community is to take these articles, these legal and constitutional human rights protections seriously, and importantly, to make the government and the courts take them seriously too. So for example, the High Court's judgment in the first defendant, Mr. Tong In-kit's application for habeas corpus protection has in part done that. That is, although the judges are, they deny the defendant's application for bail, they did try to interpret Article 42 of the NSL, the so-called no bail in principle provision, in accordance with the principles of presumption of bail and presumption of innocence. That is, although the judges are assigned by the Chief Executive Carrie Lam, they still agree that the rights principles in Hong Kong's judicial practice should be applied. And this is just one of the examples. Others include efforts of scholars to write about and talk about the NSL to inform the public and the legal community, despite the risks posed by the NSL. And many I see are in today's audience too. I hope the Q&A session can further stimulate us to think about what we can do. And no one is more convincing to talk about this than Jerry himself, as he set an example of speaking out and stimulating actions, not just on Hong Kong, but many urgent issues as an outstanding academic, advocate, and public intellectual. I'll stop here and I look forward to the discussion.
Jeff, thank you for highlighting the Hong Kong dilemma, which I now write about every day. And thank you for creating and editing my blog. As you know, all of you know, I'm notoriously low tech. I don't even know how to find my blog. I've never used Twitter, but you're helping to put my views on the map, and I'm very grateful. Well, now we turn to Daniel Yuping. He has been, in effect, my mentor for over 2 decades, since he first turned up. The late Tim Gillette, who did so much to establish NYU's early work on criminal justice, introduced me to Yuping, who was getting his doctorate at the University of Washington, working on criminal justice in China. And he has worked with our U.S. Asia Law Institute at the very start. He's continued to advise us while he's pursuing his efforts to avoid decoupling between the U.S. and China. Ping, you also were the editor of this monumental book. Yes. And you must just say a word about that.
Okay. Thank you so much. First of all, I want to add my congratulations to Jerry's extraordinary career and life, and also the benefits we all receive from your good career and a personal interaction. So secondly, I think that Jerry start the China area from the academic field, and we return them as his mentee or his former student with this book. Unfortunately, this book is in Chinese, but has 40 scholars from the 3 different places, the mainland China and Taiwan and Hong Kong. We all gathered our thoughts through this book, and as a collective memory of Jerry's scholarship for the 3 places. We call the street, 2 sides and the 3 places, 两岸三地, for the last 40 years and even 60 years, since Jerry started this field. So I'm fortunate to be, working with Jerry for many years, and benefits enormously from Jerry's, scholarship and a personal, the relationship. So, and I start today with my, the thought about how to reconduct China's 4 decades reform. First of all, I should say I agree with Ara's point and Jerry, of course, Jerry's question and answers and my answer. So yes, the U.S. helped China, the Western helped China for the last 4 decades is fruitful. I myself is a live witness. So I can tell, from many of my friends who are still in China, those efforts generate a lot of the good things for China, for Chinese people. However, I want to say something changed dramatically since the last, decades. And as we know, today's topic we talk about is arbitrary detention, as Ara mentioned, and Jerry and all the USALI colleagues and many other, scholars and the NGO people from all over the world to come to help China. We successfully get rid of the old-fashioned arbitrary detention. Just think about it. 40 years ago, Chinese people can be locked up arbitrarily without any recourse. Now we successfully get rid of the 收容审查, we call the sheltering for investigation, which demands no reason you can just lock people up for investigation. And 劳动教养, re-education through labor, which is very severe, the way to restrict people's liberty, and also 收容教育, custody for education, and all kind of the things, and custody for repatriation. So we successfully get rid of the old-fashioned arbitrary detention. That's certainly a great progress. I think we should congratulate, on this achievement, which is a result of the international cooperation. And China, I think a lot of people can recall China signed the ICCPR in 1998, but haven't ratified it, mostly because those old-fashioned arbitrary detention. But now we ask another question, why did still not ratify the ICCPR? Because something changed. I think I have 2 observations for the last 10 years. China have the drastic, rapid change on the rule of law program. First of all, the China now embark on the path to create the old style of the social control. We call the party state system. As many recorded during the 80s, China has a new reform, so-called the separatist party from the state, 党政分开. But now, if it's not all together, merged together, but the party certainly takes the role of the state apparatus. So we call it the merging of this party and the state became the reality now. I think that's worried a lot of people. They have the huge impact on the liberty of the individuals in China. And for example, now the Chinese government restored to the old-fashioned campaign-style social control. Old-fashioned, we call it strike hard, but now they don't call the strike hard that often. But they use this as a way to control the society. For example, in minority area in Xinjiang, and they use this technology institute to confine the people as large scale as millions of people, as a lot of scholars estimate, which is not happens in the normal way, not under the old-fashioned arbitrary detention, not under the criminal procedure law. But on the other hand, we see a huge change since, 2 years ago, China inaugurated a new supervision now. The party has a big weapon to purge its political foe within this party, but also it's not limited to the party or state officials, but it can touch upon ordinary people's life. So under this supervision now, the Chinese government and the supervision committee, or we call the party disciplinary committee, can detain anybody, not only the officials, whoever they deem necessary for their investigation. So that has been very, very, bad for our, the rule of law program. So I think we have to see the China issue not only through what they have done already, but we have to see what is the new development, to Chinese people's, to China's legal system. So that's, I think we should see as a very big issue, and we probably need to retackle this new challenge. And I think I should stop here, and I would like to hear anybody's, the comments on that.
That was a terrific insight into one of the most prominent human rights problems we are confronting. I'm so glad you mentioned the Xinjiang horrific behavior of the PRC in this context. And I should mention here a commercial for the series of seminars I'm doing with Professor Teng Biao, former professor at one of the leading law schools in Beijing, who's now in the United States. We have a program sponsored by the New Schools University in Exile program. And every Wednesday, 2 to 4, we go into criminal justice in China and legal institutions. And tomorrow we're talking more precisely about what you've mentioned, Yu Ping, arbitrary detention in its various forms, and the new National Supervisory Commission. Jamie Horsley and others have published wonderful pieces on it. Yuja and I are working on aspects of it. These are crucial questions, and of course, we should have a serious discussion on this. So far, I must say, I'm delighted with this program. We've heard from the Gang of Four on public international law. We have heard from the 3 representatives as the Chinese Sangha Daibao with respect to arbitrary detention. But now we have to move on to our final topic, which broadly looks at the development of democracy, rights, and human rights and rule of law in East Asia.
Yes, so thank you very much to this group of discussants. That was very rich. So if you all step down, we'll bring up the next group to just talk about democracy, rule of law, and human rights in Japan, Taiwan, and Korea. And we have with us, and I apologize, I've just scrambled the order of those countries. We have with us Song Sang-hyun, president of the Korean National Committee for UNICEF, who was the 2nd president of the International Criminal Court. While he was an advisor to Korea's Supreme Court and Ministry of Justice, he contributed substantially to the reform of Korea's litigation system, including its criminal procedures. We also have Luo Chang-fa, who is Taiwan's representative to the World Trade Organization, with us from Geneva today. He is also former justice of Taiwan's Constitutional Court. and also Frank Upham, law professor at NYU and co-founder of our institute. He is still a faculty advisor to the institute. He writes and researches about comparative law and society in Japan and China. And finally, Margaret Lewis, law professor at Seton Hall University, one of our affiliated scholars, who researches and writes about law in mainland China and Taiwan with an emphasis on criminal justice.
Well, let's start off. Sung Hyun, I'm sorry to keep you up so late. I'm glad to see you. You've taught at NYU before as well as at Harvard, but I haven't heard from you recently. So please give us a few good thoughts.
Thank you very much for this opportunity. Good evening, ladies and gentlemen. May I begin by offering my heartfelt congratulations to Professor Jerome Cohen for his enormous contribution to democracy in East Asia over the last 60 years. He was indeed instrumental in bringing about and nurturing universal values of humankind presently flourishing in East Asia, particularly in Korea. I first met Professor Cohen in 1974. By that time, he was already widely known as founder of America's study of law in East Asia. And his visit to North Korea in 1973 created the immense sensation in South Korea. You were introduced to Korean public that way. I was then teaching law at Seoul National University and serving as head of its Law Research Institute. Remember, I invited you, Jerry Cohen, to speak as keynote speaker on law and society in Korea in 1974. Looking back, this was a high risk for both of us. As many of you may recall, a military coup d'etat in 1961 had brought in a government that launched Korea on its way to economic prosperity, but at the same time grew increasingly authoritarian. Anti-government demonstrations demanding civil liberties led to arrest, torture, and convictions of many, many students, workers, and dissidents. Already, Professor Cohen began to speak up I believe in the early 1970s against the military dictatorship in Korea. He wrote to the New York Times, along with Edwin Reischauer, the then U.S. ambassador to Japan, sharply criticizing the military regime in Korea. When he arrived at the Tokyo Haneda Airport for his connecting flight back to New York, after his powerful keynote speech at my law institute in Seoul, he expressed his deep concerns about the fragile state of democracy in Korea and its future at the airport press opportunity. This seriously displeased the military authorities, who persistently treated Jerry Cohen as a de facto persona non grata. I was also subject to police interrogations. It was a difficult and dark time for democracy, the rule of law, and human rights in Korea. The voices of those fighting for these basic values were becoming silent, but not Professor Cohen. He braved on. He remained practically the only foreign academic who stood vigilant and constantly spoke for democracy in Korea until General Park Chung-hee's assassination in 1979. Over time, Jerry's intellectual voice found a huge echo inside Korea. Despite tight censorship, various types of bullying and shadow following, he was a great source of hope and inspiration for those who fought for democracy and human rights in my country. Fortunately, as you all know, this particular story has a happy ending, with Korea becoming the prosperous, thriving democracy as is today. Jerry helped bring about this happy ending. His encouragement, courageous critiques, clear-eyed logic, and encouragement coming from compassion taught numerous generations of Koreans the importance of democracy and civil rights. We in Korea owe him a deep debt of gratitude. Thank you, Jerry.
Well, I didn't expect that, Sang-hyun. I thought you might talk about your recent accomplishments in Korea and as president of the International Criminal Court, but I can't disagree with the word you said. You brought back many memories of some of the most exciting moments of my life, and I was delighted to get acquainted with you and to work with Kim Dae-jung, Kim Yong-sam, and so many others who brought about Korea as a great success. It's a great lesson for the people of China to know that people who share the Confucian Buddhist traditions can bring about a functioning democracy, despite all those who say East Asians really require authoritarianism. And I hope you continue your work to continue to bring that about. Now, what's interesting to me is both you and our next speaker, Justice Chang-Fa Lo, have been distinguished law school deans of the greatest law school in your country. And then you've gone on to judicial work of great distinction. In addition, like you, Justice Law is a prolific and able scholar. And we've worked together most recently with Professor William Alford at Harvard on a book that perhaps he'll say something about. Chang-Fa, you're now the WTO representative for Taiwan, but I welcome your thoughts on anything.
Thank you so much, Jerry, for including me in this important event. Well, I hope it is appropriate for me to turn to some lighter subject and take this rare opportunity and valuable one to raise 3 questions for everybody to reflect and for Jerry to inspire us again. I trust that more serious issues will be tackled by my capable co-panelists. My first point has been touched upon by President Ma Ying-jeou and Professor Belkin about foreign engagement in the democratic development in Asia. Taiwan's development of rule of law and democratization, as well as its human rights protection, have very close links to foreign factors, including some foreign government having pushed Taiwan to democratize, as well as a limited number of foreign figures, such as Jerry, who closely observed and engaged in the development of human rights and rule of law. Taiwan and its people basically do not see such engagement as an undesirable foreign interference in domestic affairs, but as a positive and fortunate development in our history of democracy. However, in many other places, foreign interference and engagement in relation to democratization and human rights are unwelcome and considered as hostile by the government. So my first question is what could be the factors contributing to such sharp differences concerning foreign engagement between different countries? And second, in the East, there are sayings about only bother your own business, not bother others, 不管闲事, and only sweep the snow on your own doorsteps, and never mind about the frost on your neighbor's roof, 至少门前雪. However, as a human rights activist, you have been so keen in helping other countries and their politically disadvantaged people. You have helped correct many injustices in different places. Such philanthropic mindset is not part of the nature of most people in most countries. So my second question is, what are the reasons contributing to you being a lifetime philanthropist law professor? And third, in many countries in Asia, a very large portion of scholars get retired at their 65 years of age. Their brains stop functioning as sharp as they used to function. But Jerry does not have any sense of retirement at all, although officially he just got retired from the university. You still have an extremely busy schedule, caring so much about the rule of law development in other countries. Just to give an example, most recently, the Constitutional Court of Taiwan issued a decision confirming the legislation which takes away the properties gotten by political parties in the authoritarian age is constitutional. Quickly after the constitutional decision, Jerry sent an email to many of us from Taiwan, including me, asking whether there is any thoughtful analysis yet appeared on this decision. He said he had not even seen any English journalistic reportage of significance on this case, and asked, do we foreigners deserve more light? Jerry's radar is still so sharp to identify important rule of law related events occurring in remote countries. He constantly makes comment on and promotes to respond to important human rights events in other countries, including China and Hong Kong more recently. So my third question to Jerry is, how can a person maintain everlasting energy and uninterrupted interest in helping people all over the world? And do you expect all of us to work uninterruptedly until 90 years of our age? Thank you very much, Jerry, for this unique opportunity.
I'll give you a few answers to those complimentary questions if I get a chance a little later, but I'm grateful to you. You're the most amazingly prolific person and most responsive email colleague I've ever had. And you make collaboration very easy for me. And I hope your WTO efforts will not preclude your continuing academic accomplishments. Thank you.
Thank you so much.
Well, now we turn to Maggie Lewis. She was there at the beginning of the U.S. Asia Law Institute. And I am delighted that she can be with us today. We've worked together in Taiwan. I was amazed at her immense competence in the Chinese language and the zest and success of her research in Chinese language relating to the mainland as well as Taiwan. And we wrote a book together in 2013 and other articles. And I remember when she asked me, I I think in 2005 or so, why do you want to establish a U.S. Asia Law Institute? I said, you know, every other law school, the students who apply to law schools tell me they have a China center, they have an East Asia center, but NYU doesn't have any designated center. I said, all we have is substances. We offer more in teaching and scholarship, but we don't have a label, we don't have a form. And so we decided with Frank Upham's collaboration and great cooperation, we would establish this institute. Well, now we have a chance to hear from both Maggie and Frank. Maggie.
Well, thank you, Jerry. And I'm here back in Taiwan, and it's all because of you. And I wonderfully hold you responsible for all that I do here. And so I do want to say a few words about Taiwan and its past and its present and its future with respect to human rights. And it was in 2005 when I was clerking in San Diego and reached out to you saying I wanted to do work again with East Asia and human rights and criminal justice. And you wrote, come work with me, I will find money. And you did, and we wrote a book, and it was on Taiwan and the liumang, these hooligans, and the vestiges of martial law that were hanging on. And there was still, as has been mentioned earlier with respect to arbitrary detention, there was still laws in Taiwan that were treating people like they were still in the martial law era. And we looked at that and re-education through labor across the strait. And I'm delighted that I can say that it was then justice law was not yet on the Constitutional Court, but the Constitutional Court kept saying that parts of this law were unconstitutional. And it was under the leadership of President Ma that finally this law was gotten rid of. And it marked a real bridge, I think, from that past where human rights were not respected to today. And now here I am 15 years later, living in Taipei this year, and so grateful to be here because Taiwan is a shining example that a democracy that respects civil and political rights can craft an effective response to the pandemic. And it really is remarkable what the people have done here. And you have such creativity. You look at what's happening with, for example, the digital minister, Audrey Tang Feng, and using technology to try to find ways to hold the pandemic in check while respecting human rights. All three branches, the main branches that we think of, there's of course 5 here, but the legislative branch, the executive branch, the judiciary are all involved. I was hearing comments by, for example, a member of the legislature, Freddie Lim, who is also known for being a rock star, and his concerns about how the pandemic response could infringe civil liberties. So people are being watchdogs. And I'll give you, Jerry, a little recommendation for a podcast on Taiwan, Metalhead Politics. It combines discussion of politics here, music, and all sorts of new things for the younger generation to keep you up on what's happening with current Taiwan. And I think it's really tremendous what's happening. But there's a lot of issues that haven't been resolved and a lot of work that needs to be done in the future. Transitional justice, just because the martial law era is now several decades in the past, as was just mentioned, the Constitutional Court is just looking at these issues. There's a lot of foment here about how to grapple with the past and move forward. Those issues are not going away anytime soon. The death penalty. The death penalty is still used here, and President Tsai's administration has been quite quiet on that. And I look at the work that we did when there wasn't even yet the U.S. Asia Law Institute. It was you and Yuping and me in China on the death penalty, and I think there's work to be done here too. Refugees, this is going to be a bigger and bigger issue as Hong Kong and the human rights there deteriorate. Right now, freedom of movement is difficult because of the pandemic, but I see this being a bigger and bigger issue in the months and years to come. And also a huge celebration recently here with same-sex marriage just a year or so ago was legalized, but that's not over with either. There's more questions. What about parenting with same-sex couples, adoption when there's a same-sex couple, the rights of single people to use reproductive technology? These issues are still on the table. And finally, circling back to the first panel and thinking of the law of the sea and what's happening in the air, certainly it's a very tense time here when we look across the strait at what's happening and the saber rattling in Beijing. And I would just close by saying that, you know, to have decisions about human rights, to choose your own future requires sovereignty, and that's not take it for granted here. And this Saturday is Double 10 Day, it's October 10th, the celebration of the founding of the Republic of China before it was ROC Taiwan, just ROC. But I look at that celebration here and it's really bringing into focus what people in Taiwan, what the Taiwanese are protecting as their way of life, and when they look across the strait, what they're rejecting. And there's a lot of strength here and a lot of questions and many more Zoom seminars that we could have.
Maggie, thanks for that terrific update on Taiwan, and it's great to know you're continuing our work there. I wish you could stimulate Taiwan scholars to produce more in the English language. They do so much of great work in Chinese language that is not made available to us. One reason we established U.S. Asia Law Institute was to try to bring more of what was taking place in Taiwan into the broader international domain. When I got to NYU, the first thing I said to then Dean John Sexton, who did so much to recruit me and to establish our whole program, was we need to do more on Japan. And I said, we have to get Professor Frank Upham to join us. Frank and I had been colleagues at Harvard, and he did join us, and he's been instrumental in establishing and running our program and instructing us about what's taking place in Japan. And more than that, he's always had the ability to ask great questions about the rule of law and comparative law. So Frank, I'm delighted you could join us this morning.
Thank you, Jerry. And that's the only thank you you're going to get from me right now. I'm not going to try to thank you for anything else because, as you know, I've tried many times and it's not what you want. So instead, I'm going to thank Joan and you. For 50 years, you have been a rock of stability for not only me, not only my wife, but even my son, who was one time wandering the streets of Beijing. You probably don't even remember that. Emotional, professional, and as Maggie said, I will find the money, also financial. So thanks to Joan, and I hope that she can share my gratitude with you. I'm going to use President Ma's structure and give three quick updates on what's happening in terms of human rights in Japan. Last year, 2019, on Valentine's Day, 13 same-sex couples filed a lawsuit asking the courts to establish their right to register as married couples. The pandemic has slowed that litigation down, so that's sort of saying slowing something that's already very slow is being slowed down even more. During that time, the lawyers and their supporters are trying to bring same-sex marriage and LGBT rights more generally to the forefront to try to create a social consensus that will help the Supreme Court, if it wants to find the denial of marriage registration for same-sex couples unconstitutional. It's a difficult issue. As I've argued elsewhere, Japanese courts have been more interventionist in many areas than courts in the United States. But one area in which they are reluctant, they certainly do, but are reluctant to intervene, is in finding unconstitutional the products of democratic process. There's something to be said for that, as we may find out soon in our own country. The second issue is constitutional revision. The Liberal Democratic Party under Abe Shinzo, the recently stepped down for health reasons prime minister and grandson of one of the Class A war criminals, has been trying to revise the Constitution to make it more Japanese, more traditionally Japanese. And as I wrote down somewhere, someone said in this panel, or the latter one, the idea that Asians like authoritarianism or something like that. I don't agree, and I think both Taiwan, South Korea, Japan are incredible examples of that. But that doesn't mean that they're not strong. They're not a minority pushing for constitutional revision that will lead to a more authoritarian society. International attention has been focused on Article 9, which is extremely popular in Japan. And I think revision of Article 9 will be very difficult for the right-wing conservatives there. But there are also attempts to revise other aspects, the preamble, and to include things like duties as well as rights. But also one that I would draw your attention to is a claim that Japan is unique and sacred. These are not great phrases if you remember pre-war Japan. I actually don't think there's much chance of this. I certainly think a lot less chance of that than things going badly in the United States. The last thing I'll talk about is criminal justice reform. The escape of Carlos Ghosn has brought attention of American media, primarily, but also some scholars, to what is called the 99% conviction rate in Japan, and arguments that criminal defendants don't get adequate procedural protection. I think that there is incredible irony in Americans commenting on the Japanese criminal justice system. I think is it the pot calling the kettle black or whatever? I think the United States criminal justice system is among the worst in the world. And for us to talk about how Japan is mistreating its participants in the criminal justice system is ridiculous, but it will continue, I'm sure. There has been a reaction to that, led by Minister of Justice Mori Masako, who was a product of NYU. And there is a deliberative council looking into providing more rights for detained suspects. And I suspect that something will come out of that, and the result will continue to be a criminal justice system much better than our own. So I'll stop there.
Well, this has been a very stimulating discussion. I wish it could continue, and perhaps we can make some reference to it in the remaining 25 minutes that we have. Now we have an open mic, and our able moderator is going to tell us how we're going to make use of that time. I regretted that there were so many other great colleagues and friends we could have included in this discussion that time didn't permit it, but perhaps we'll hear from a few more people on the open mic, and I'll say a few words as Catherine will at the end.
Thank you, Jerry, and thanks to everyone, this last panel and also all of the previous discussants. This has been a terrific example of 100 flowers blooming. A really wide spectrum of ideas have been aired, and of course we only had time to air them, not as Jerry is complaining, justly complaining, not time to fully develop them. But if you thought that the comments were too brief so far, they're going to get even briefer. So now at open mic, we only have time, if we want to allow an opportunity to as many people as possible in the remaining 20 minutes, we're going to give each person who comes up to the mic just 1 minute to speak. which is extremely short, and I will fully acknowledge not fair, but we're trying to be fair to the people who are staying awake late in Asia and to end on time. So we've pre-selected a few people to come up based on their comments that they had submitted either before the program in the Google form that we had circulated to all the registrants, or earlier throughout this program in the chat panel. We've pre-selected a few people to come up. And so if the USALI staff will start bringing some of these people up on stage, we're going to bring them up in groups of 3 or 4 at a time. And in the first group, we wanted to invite Mr. Ko Young-tong, who is a lawyer practicing in New York City, an international private and public law practice, and one of our Institute's oldest friends and supporters. Also Ren Ito, who is a former diplomat for Japan turned entrepreneur, and Jamie Horsley, a senior fellow at the Paul Tai China Center at Yale Law School, and one of Jerry's colleagues at the Paul Weiss Law Firm back in Beijing some few years ago. So if those 3 will come up, while they are being brought on stage, and I'm looking to see, we have at least a few of them there. I was going to just quickly read also 1 or 2 of the comments that have been submitted in writing. Again, lightning round. One of Jerry's colleagues at NYU Law School, Professor Harry First, wrote this comment. He said, "I want to thank you, Jerry, for your long and deep contributions to our law school, which began even before you joined the faculty when you came to talk to us about the importance of studying East Asian legal systems. And it has continued with your teaching our students and our faculty about all aspects of East Asian law and politics." And one of our recent visiting scholars, Judge Hikaru Iwaki in Japan, who left us just a few months ago to return to his position, wrote, "Dear Jerry, I always admire your outstanding contribution to constructing U.S.-Asia relationships. I hope we see more of your works." And Susan Finder, who is in Hong Kong, writes, "Thank you for creating a 大家庭, big family of students who have developed their lives to law in East Asia." So do we have now, it would be easier in person, of course, do we have, yes, we have Ko Young-tong. Would you go first, please? 1 minute, sir.
I'll be fast. On this occasion of celebrating Jerry's 60 years of outstanding scholarship, I was thinking what makes Jerry special, what distinguishes him from many other scholars who have taught for 60 years. So how does a Jewish kid from New Jersey become the world's preeminent scholar in Chinese law? I've been trying to crack that secret so that I could imitate and even emulate him. Now, almost 50 years later, I think I have cracked the secret. First of all, he is not a traditional scholar. He is something else, a different kind of hybrid academic animal. First, he is an explorer. Like the famous archaeologist Indiana Jones, instead of staying in musty libraries, he takes the path less traveled. As a young teacher at Berkeley, he volunteered to go to Hong Kong in the 1950s, which was not then the mecca of scholarship. Second, he is an empirical scientist, not an academician. Instead of ruminating on hypothetical, he probes into real-life examples that raise interesting questions. Thus, he goes to the slums of Kowloon to interview Chinese refugees from communist China. Third, he is an opportunist of people and situation. He leverages not only his own intellect and skills, but he harvests the knowledge and resources of others, including his colleagues, students, and even his friends. We all have experiences of that. He is also an opportunist of situations. He used the Chinese refugees in Hong Kong as his resources. He used China's expansion into South China Seas to wade into the law of seas. He has taken situations in Taiwan, Hong Kong, and Xinjiang to highlight human rights. Finally, Jerry is a charmer and a seducer. He employs his deep, gravelly voice and his mustache smile to make us do what any self-doubting person would not otherwise have done, to pursue ideas and ideals. So that, Jerry, is Jerry, that is in a nutshell, Jerry from New Jersey. So congratulations, Jerry, and thank you very much, Jerry.
My great tennis partner and mentor in tennis and everything else. Thank you.
Thank you. Ranita, would you like to speak next?
Thank you very much, Catherine. Following Jerry's charm for the past 20 years, as a former student, it's a great pleasure to join the celebration. A few years ago, there was a similar occasion where I had the privilege of proposing a toast to celebrate Jerry's great work and the completion of Japanese government endowment. And I asked Jerry, what should I include in my remark? And Jerry said, just as Frank would have expected, say something other than how Jerry inspired me and changed my life. Obviously, that was a bad question that I asked. So I want to celebrate this special day, recalling all the happy moments with Jerry, John, and even the exams when I was a student and being a speaker at one of your weekly speaker series, where Jerry told me to come unprepared, ended up never stopping grilling me. So I treasure all those memories. Just one thing, one evening, right after a very, very heated roundtable discussion at the Council of Foreign Affairs up on the 68th Street about the human rights and situation in China and the maritime disputes over South China Sea. We all drove down to a small Chinese restaurant near the school and continued our discussion over dinner with another round of discussion of the legal theories, with some more real life examples, and also with everybody's struggle with his or career in their life. That was the kind of the moment I remember equally as inspiring, as equally thought-provoking as your class, Jerry. And it was a purely happy moment where you feel that you are part of Jerry's big family with friends from all over the US, Asia, and the world. And I truly believe that the Japanese government endowment, which Trevor mentioned at the very beginning of this session, was created with a conviction that such an exchange of views and discussion based on our common language, which is law, will be the most important building block for the peace and prosperity in the East Asia region. I'm echoing all your students across the world, Jerry, about how much we appreciate your guidance and how much we love you. Thank you, Jerry.
Ren, I'm thrilled to see you. I thought this morning I should have written you to make sure you knew about the program. And of course, you have done more than anyone else to get us the support of the Japanese government. And now, if you'll only go to work on all the other governments of East Asia, I'll be deeply grateful.
I'll try to get some more passport, yes.
Hi, I think it's my turn. Hi, Jerry. Yes. Hi, everyone. It's great to see you. I'm Jamie Horsley. I think these wonderful panels this morning just illustrate how dynamic and warm and fun all your events are. You have generations of students and colleagues and friends with you today. I saw there are over 170 people. And it's through us and these wonderful ideas and exchanges and networks that we will keep alive your example and your scholarship and your story for many more generations to come. And I'm also was wondering, watching you, especially the first panel, whether your example will also serve to keep your signature bow tie from the dust heap of history. I only saw 3 of you this morning, but they're all in the first panel. You, Jose Alvarez, and Peter Dutton, all sporting your bow tie. And I was thinking, I'm sure others would have too, except that we dress so much more casually today. But for that, I bet we would see a lot more bow ties. And my challenge to the women here is we really ought to, in honor of Jerry, come up with a counterpart that we could use in honor of you, Jerry, and to keep that alive as well. And so again, Wan Sui, we love you, you're wonderful. Thank you so much for bringing us all together for yet another fantastic event in which we learned and had fun at the same time.
Our mutual dear friend Sandy Rant couldn't be with us today, but he is another aficionado of the bow tie.
Indeed.
Jamie, I can still see you in my mind's eye in April '74 when we were introduced at a banquet in Taiwan. And I admire everything you've done in law practice and in scholarship. As recently as today, I already plugged your article on the National Supervisory Commission.
I appreciate that. Thank you, Jerry.
Okay. Thank you all. And now we're going to quickly, we've already, in the interest of efficiency, brought up the second group of commenters. And they are Hugh Scogan, who has had a corporate law practice in China for many years and is now teaching Chinese legal history at NYU. Sharon Holm, who is Executive Director of Human Rights in China, and Madam Tang Fumei, who has been the National Policy Advisor to the President of Taiwan and a former Minister of Taiwan. If you would speak in that order, please. So Professor Scogan, the mic is yours. And you are muted.
You.
Unmute. Thank you very much. And I just want to do a quick shout out to Jerry, a moderately self-interested, thank you, for all the work he's done supporting the field of Chinese legal history. And embedded in that, I did want to make a comment on some of the discussion today about this problem of decoupling, because part of Jerry's contribution is that in the early days, he really encouraged the preservation of primary sources for Chinese legal historians. And for centuries, legal historians of China were sort of downers because they'd look at the Analects and they'd look at the criminal code with endless provisions on whacking people with sticks. And they thought, that's it, that's the Chinese legal tradition. And so therefore, it's hopeless. But as historians in recent decades have been able to get at the primary sources, you see that the Chinese tradition, it's not hopeless, it isn't unchanging. For 4,000 years, all it's done is change, and it's constantly evolved. And when you see those primary sources, you can see very practical, well-intentioned people grappling with these materials and trying to solve real human problems. At a 30,000 foot level, nothing much changes, but there's a lot more percolation there. And therefore, and also, history tells us that nature abhors a vacuum. And so if in these current sort of transient, difficult periods in America, if we demonize China, pull up the drawbridge, decouple, that creates the vacuum that will bring about precisely the worst results. And so just again, a thank you to Jerry for supporting that field and a sort of historian's note, I think, of optimism about the importance of the kind of engagement that most of the people on this call are involved with, and a word of optimism in light of how this has developed over the long, as longue durée, as the French say, of Chinese history. So anyway.
Bringing you, Scoggin, to NYU was a great boost to our East Asian program. I wanted it to have historical depth, the ability to give students the necessary background, and Hugh has proved to be a great teacher. And as I'll say when I mention Miss Jiang Fumei, from the very beginning of the early 60s, I was thrilled at the prospect of people telling us more about China's great legal tradition, as she certainly did earlier in her career. But first we'll hear from Sharon Holm, who is another NYU colleague who adds to the stimulus of our teaching and research. Sharon, glad to see you.
Hi, Jerry. So first, congratulations and much love to you and Joan, who I see in the back, and thanks to the wonderful 100 flowers that have been blooming all morning. So inspired by Yuhua's China in 10 words, here's my Jerry in 10 words. First, China. How much poorer our understanding of China would be without the field of Chinese legal studies that Jerry pioneered and developed. 2, North Korea. Who but Jerry could tell hilarious stories about his and Joan's first visit there and go on to be a black hand behind the democracy and human rights struggles. 3, Taiwan. Who but Jerry could help train a future president and then promote so effectively an innovative alternative model for human rights review of a state. 4, South China Sea. Who else, along with his partner in crime, Peter Dutton, could make international waters boundaries and maritime disputes so compelling and relevant to non-maritime experts? Hong Kong. Who else has so persistently, in face of Hong Kong is dead proclamations, continued to post incisive, necessary legal and political and moral questions and analysis, in Professor Chang's words, with your radar sharp antenna, and to remind that so much can and needs to be done, as Yujie has also signaled. And then finally, people. First, Joan, art historian, writer, photographer. Jerry, you and the family, 7, are so blessed that you have had her and have her in your life as a partner and friend. 8, 9, 10. Colleagues, generous generations of students and friends spread out all around the world. These words often overlap in Jerry's world. So Jerry, while I miss being your student, I am so honored and grateful to be your colleague and friend. And over the decades, I am indeed really your student. Much love and gratitude.
You're terrific. Thank you, Sharon. And now we hear from Zhang Fumei, whom I first met, I think, in 1962 at a law school conference in Chicago. She was a Northwestern student, and I persuaded her to transfer to Berkeley, where I got my start, and she got her start in the LLM. And then she came with me to Harvard and wrote a great book about Chinese legal history, and since then has gone into public life in Taiwan in the greatest cause that one could work for. Fumei, welcome.
Thank you, dear Jerry Cohen. Professor Cohen, I also want to say hello to John in the background, and I miss your 3 lovely boys or children, Peter, Seth, and Ethan.
Good for you.
Say hello to
you were their babysitter.
I know, and I also take care of your house whenever you have to go away, you know. So it's a long-term friendship, and I still remember how you come back to Taiwan and stay at the Grand Hotel and play tennis or go swimming, you know. And Ira, I think, is with you.
Yeah.
Okay, and I wanted to tell you, you probably didn't know, you have changed my life. Back in August of 1991, I was offered to campaign for a political position that's a member of the National Assembly. I was wondering if I should go back to Taiwan to run for some political career. And you told me, Fumei, you ought to go, because as a member of the National Assembly, you can participate in the revision, 修宪, of the ROC Constitution. And with your blessing, I took a big step back and I stayed there, and I never regretted it. I really enjoy my life there. Here, I mean, right now it's our time is close to 10:30, but I was waiting for this moment. But for the problem with the coronavirus, I would have gone to New York to be with you to celebrate your 90th birthday, July 1st. And do you know, my birthday is coming up in a few days, and I'm going to turn 82. It's only 8 years younger than you, but you have accomplished so much. I really envy you.
Well, I'm glad you're still advising President Tsai. You were the one who introduced us at several dinners to her and enabled me to become acquainted with her. And so far, so good.
And I also, in addition to my interest in political issues, I've been devoting myself to the conservation of Taiwan black bears for the past. Taiwan black bear is a huge animal, you know, but it's sort of representing Taiwan. It has a big white fur, white color V, so it's a victory bear. So
you also are trying to preserve the U.S. Asia Law Institute through your recent very generous contribution.
Thank you so much. Yeah, and some people said it's regretful I have to give up my Chinese legal history career and become a politician. Okay, but Professor Dennis Twitchett said, Fume, you shouldn't have gone into politics, but I want to tell you, you corrected my thought, and I ended up becoming involved in politics in Taiwan. I'm an opponent of President Ma. I didn't like him. He's a KMT guy.
We have to go on with the program, but I hope you'll return to legal history because you still have another decade ahead of you.
Oh my God. I'll live to at least 90 years just to match your career, okay? Yeah, I don't want to take up too much of the time because I'm as active as you are. And finally, I see John. I'm a grandma of a black bear, so to speak. Ferocious looking animals, but I've enjoyed it.
Thank you, Fume.
Thank you. Nice talking to you. Hi, John. I miss you.
It's lovely to talk to you and lovely to hear.
Thank you so much.
Great.
And now we're going to have a last group of 3 people commenting. You all have noticed that I have unforgivably been lax in my duty, which is to keep the trains running on time. We are a little bit behind, but we have 3 last guests that we want to give a chance to say a few quick words, and then we'll wrap up. And so I want to introduce briefly, we have Jan Barris, who is Vice President of the National Committee for U.S.-China Relations, who has been a collaborator of Jerry's for many years and decades. Also, Albert Hung-Yi Chun, who is a member of the Hong Kong Basic Law Committee of the NPC and a law professor at Hong Kong University, and Ken Wasserman, who is a New York-based lawyer and one of our frequent guests in our lunch programs back in the days when we used to actually have our speakers at lunch in NYU, in an NYU building rather than over Zoom. So if the 3 of you will very quickly, briefly make your remarks, then we'll end our program a little bit late.
Jerry and Joan, I will be very brief. I promise, Catherine, I will not repeat what I said in my message. I just want to say on behalf of everyone, not just on this call, but those who have known you over the years and love you and would have loved to be here, but not just online, virtually, but with you in person, to tell you how much we love you, how much we respect you, how much how you have made the world so different through your passion and commitment. And when I say you, I mean both you, Jerry, and you, Joan. The 2 of you make an extraordinary couple. And everyone in life should be blessed with the kind of partners that you've been to one another and the kind of joy and commitment and passion for doing good and bringing justice into the world that the 2 of you have embodied. So that's it from me, except to say, Joan, I love your new hairdo.
That's a COVID product.
I figured.
I'm delighted to see Albert Chun here. We have a kind of trifecta of ex-law school distinguished deans from Asia. We've heard from South Korea and Taiwan, and now Albert, who's been dean of the Hong Kong University Law School, as well as playing a major role in public life, has made the time to stay up late and join us. And Albert was my student 40 years ago at Harvard Law School, and I admired his intense academic ability as well as his other personal qualities. And he plays a great, important, intermediate role in Hong Kong's struggle. Albert, we're glad to see you.
Thank you very much, Jerry. It's very, very nice to see you, and also Joan. Best wishes to both of you. And I also just saw Frank Upham, who was also my teacher at Harvard in 1981 to 82. I wrote a message, which I hope Jerry can read later on. I just want to mention 3 points in that message. One point I made is that I did a search of your contributions to Hong Kong Law Journal. There are quite a number of contributions, including articles which you contributed a few years ago, and some were co-authored with Yu Jie, whom we just saw, and some were your own single author piece, like a piece about your experience in Hong Kong in 1963 to 64, interviewing refugees from mainland China. And your piece was published in 2017 in Hong Kong Law Journal. But I also discovered that the piece you published in Hong Kong Law Journal, which was most often cited, was a piece published in 1988 called Sex, Chinese Law and the Foreigner. I don't know whether you still remember that piece. It has been cited.
Yeah, I'm looking for it for my discussion tomorrow. Was it 1988? So late? I thought it was earlier.
Yeah, it was cited more than 300 times, that article.
Well,
and I also,
the title was sexier than the substance of the article.
Yeah, the substance was about criminal law and the security administrative punishment law. And I also mentioned another article you wrote, which I remember very, very well, which you wrote after the Court of Final Appeal rendered its decision on how to react to the NPC Standing Committee's interpretation. And I think you gave a very balanced and very insightful analysis of that decision, the best which I've ever read on that particular controversy. And in the end of my message, I wrote about the Chinese tradition of the scholar, intellectual, and man of integrity, or the Jinzi, who is socially committed. And I said that for me, you exemplify this ideal of this Chinese tradition of the committed, socially committed scholar, intellectual who has wisdom and courage and benevolence. 智仁勇. So that was my concluding paragraph.
Thank you, Albert. We're very much happy that you could take part.
Well, very nice to see you.
And
Ken
Wasserman?
I'd like to briefly focus on that part of Jerry who's a humble friend to his students and who regularly encourages diverse and contradictory perspectives on contentious and possibly unresolvable issues, including Chinese and Asian human rights, legal studies, and including rule of law, that broad and to some too ambiguous concept. For example, it's not unusual that you immediately follow your prescient and far-reaching presentations with the word, "Comrades, lend me your criticism." That impression lingers. Thanks very much.
Thank you, Ken. It's been a pleasure to have you as the most faithful New York lawyer attending all of our exercises, including those at the Council on Foreign Relations. It's been a pleasure.
My pleasure.
And now we have come to and actually exceeded our allotted time. I've really enjoyed this time, though, together with all of you. If we were not in the middle of a global pandemic, of course, we would have held this retirement party for Jerry in Greenberg Lounge in Vanderbilt Hall in New York City. And we would have enjoyed toasting him and Joan together with all of you in person. But of course, if we had held that event at NYU, it wouldn't have been all of you. It would have been a portion of you because many of you are actually sitting in Asia. And so we have to recognize the silver lining that doing the celebration online has allowed us to have a much broader, wider participants than we would have had otherwise. So thank you all for celebrating with us today. Thank you for your past support of Jerry's work and of the work of the U.S. Asia Law Institute. We look forward to staying in touch and to continuing this dialogue, contentious and lively and inspiring as it is. So I'm giving the very last word to Jerry before we sign off.
Well, this has been as good as I could have hoped for. It could have turned out to be chaos. And thanks to Catherine and her very able staff of our colleagues, Alexis Sanborn, and of course, we saw Eli, where was he, Blood Patterson earlier, and Amy Gao, and others who've done so much. This was a technical success. We weren't even interrupted once, despite our being at Cape Cod, where we often have difficulty with internet communication. I couldn't have been happier with this. It's been stimulating. My only suggestion is that we have a series of serious seminars trying to implement the kinds of ideas we've heard. President Ma got us off to a great start in the spirit of his suggestions and criticisms. And this is the spirit we've always had over the years. And I hope we can continue it. I got interested in this because I'm a product of World War II. Not that I fought in it, I was too young. I was in junior high school and high school. But we wanted to save the world. And as mentioned, I'm of Jewish background, and I came from a family that lost many relatives thanks to Hitler. And that has been a motivation for me all my life. Thank you all.